Hello? Hello? Hello, are you hear me? Hello. Nanda sir, are you hear me?
Yes, sir. Yes, sir.
So, what to do? Continue.
So we'll start at 2:30 p.m. I sir has told me that there is some start at 2:30 p.m. sir.
Oh, okay, sir. Okay. Hello, are you hearing me?
Yes, sir.
Okay, so welcome all of you. Sorry for the delay, and we will thankful to our next resource person, Sri Meti Satya Sai Srinivas. So we will gain our knowledge on patenting and drafting uh, with Srinivas sir. And Srinivas sir received his integrated BE and ME degree in Electronics and Communication Engineering from the Andhra University. And from September 2016, he is with Department of Electronics and Communication Engineering at NIT Pondicherry. And he is serving as research associate under a project entitled as a special manpower development program for chip to system design. And it is funded with Ministry of Electronics and Information Technology, Government of India, with the research grant of 1.6 crore. And simultaneously, he is pursuing his PhD degree from same department and institute. And his PhD title is FPGA Prototype for Automatic Speech-Based Recognition Systems. From July 2020, he is serving as chair for IEEE student branch at NIT Pondicherry. In 2015, he was awarded uh, a credential Mathwork R certified MATLAB associate by Mathworks R Incorporation USA. In 2020, he received a prestigious award entitled Augmenting Writing Skill for the Articulating Research, along with the cash prize of 10,000 from the Department of Science and Technology and Ministry of Science and Technology, Government of India, for his science article entitled as Automatic Spoken Language Recognition System for Indian and Oriental Language using Digital Signal Processing and Machine Learning approach. Uh, the said article ranked 47th position out of 112 best science articles selected out of around 2,000 submissions under the PhD category across the India during 2019. In 2021, his research proposal entitled a portable healthcare monitoring system for automatic voice pathology detection from speech signals. It is ranked around the 36th position in the top 100 research proposals selected out of around 6,000 submissions made to the Swadeshi microprocessor challenge. Innovate solution of for Atmanirbhar Bharat conducted by Ministry of Electronics and Information Technology, Government of India. Under this challenge, he won prize of 1 lakh for entering into semi-final stage. He is currently developing a working prototype of proposed system using a Swadeshi microprocessor, and its name is Vega AS1061. Designed and developed by CDEC Trivandrum. He has more than 5 years of research experience in FPGA-based industrial experience by working with uh, eminent scientists and engineers at CDEC Hyderabad during 2015 to 16. He authored around 9 research articles and he gained more than 90 citations and have 6 H index, and I index is around 10 for 3 research publications. So his research interest basically focused around digital speech signal processing, machine learning, and PGA digital Villi systems. He also published a patent, but currently it is pending for the grant. So we will with Sri Nivas sir for gaining the knowledge on the patenting and drafting. And I'm again thankful for accepting our invitation. So please, Srinivas, sir, please give your suggestions for patenting and drafting to our audience.
Thank you, sir, for the brief introduction. Just give me a minute. I'm sharing my screen. Am I audible now, sir? Is my voice is clear, right?
Yeah, yes, sir. It's very clear.
Okay, sir. Thank you. Yeah, good afternoon, everyone. Welcome to the third session. In this session, I'm going to discuss about a brief insights into the forms, fees, and filing procedures for the Indian patent application. So far, in the past two sessions, I have covered briefly, elaborately into the details of the specifications. That is like preparing Form 2 along with the drawings. So these two are the primary steps before proceeding to the patent filing. So we have to be ready with either the provisional or a complete specifications accompanied with drawings. So in this session, I will be covering you after having these specifications in hand, what are the various steps that a person needs to take care of in order to smoothly file a patent application at the designated patent office in India. So moving on. Uh, Actually, the patent processing in India is entirely based on the Patent Act 1970, and time to time the act is being amended. And accompanying with the act, we have a set of rules. So we call it as the Patent Rules 2003, and the time to time the rules are also being amended. So it is we have in the Patent Act, there are various number of sections and chapters which briefly discuss about the law of patenting. And in the rules, we have around 130 plus rules, I guess. I don't know the exact number, uh, which governs various timelines, and also defines the uh, instruction sets for processing an application right from filing stage till grant, and also for the post grant. So as per the law, there are so many provisions which are provided in the Act and rules. and there is a systematic procedure that one needs to follow right from the filing of the patent till grant, and also for a period of 20 years to maintain that patent. So once a patent is granted, the protection will be enforced for a time period of 20 years. So right from the beginning till the expiry of a patent, each and every cycle, we will be discussing about various aspects, and these aspects will be completely governed under the Patent Acts and patent rules. So one should be very much familiar with the Act and rules in order to process your application in multiple stages. So what are the prerequisites that one needs to come across in order to file his patent application on his own? So I have, just for your better understanding, I have given some links. You need not necessary to go through all the details because it is very difficult to understand each and every line of the Act and rules. But I will just guide you the minimum set of Act and rules that one needs to take care of for processing your patent application. So if you are interested to know about the Patents Act, this is a link given by the Patent Office. So you have both a PDF version and then HTML version. So this is the complete Patents Act. So if you see, we have a number of chapters, and in each chapter we have a number of sections, so on and so forth. These all are the guidelines that will govern the patent throughout its life cycle. So wherever necessary, I will be just cross-referencing few of the sections which will be applicable at the time of filing, at the time of processing your patent application till the grant. So similarly, just like Act, what I have mentioned, we also have a set of rules. So I'm just opening the HTML version of the rules in online. So these are the patent rules 2003. So again, we have a hierarchy. We have a chapters, and within the chapters, we have rules. So you can just scroll and check. Time to time, some of the rules may be omitted, and some of the rules might be reframed, or new rules might have been introduced. So currently there are 139 rules are available. So this is a brief details of Act and rules. These Act and rules are written mostly in the legal language, but for a common man, it is very difficult to understand the Act, rules, and procedures of the Patent Office. Why? Because these are generally phrased in the legal language. So how a common man will be able to understand much clearly? So for that purpose, the Indian Patent Office has taken an initiation, and it is releasing frequently a document which we call it as a manual of the patent office and practice procedures. So all the legal jargon which you see in the Act and rules is omitted, and it is written in a much and simpler fashion by using a simple English, so that majority of the people get aware of what is the procedures being followed at the Indian Patent Office while handling the patent applications. So I suggest the readers or else the participants who are attending this webinar, if you want to have a glimpse of the patenting procedure that is adopted in the Indian Patent Office, and also the guidelines which are mandatory for filing a patent application on your own. So what are the rules and regulations that you need to be taken care of? Everything systematically they have prepared this document. So when compared to the acts and rules, this is a much simple document for ease of illustration. So you can just, if you have time, you can just go through it. And here they have avoided the use of sections and rules. But at the right side column, you can see wherever necessary, they are telling this information has been taken from so and so section and from the act or so and so section from the rules. So like that cross reference has been given. So if you're interested, you can just go through this for better understanding. However, throughout this session, I will try to cover minimum basic requirements for which that will help you to file a patent application. Okay, moving on. And one more thing, important point that I would like to mention, the manual, what I told you just now, it is only intended to serve as a quick reference guide to understand the patent office usual practices, procedures, patent act and rules. So, but it does not have any legal significance. So this is one of the important observation. So now, without wasting any further time, we will directly jump into the what are the documents which we require for filing the Indian patent application. Documents required for filing. So in the last two sessions, we mainly focused on provisional or complete specifications. So at that time, I have mentioned you like these specifications are usually submitted in form number 2, accompanied with the drawings. So, but you have to prepare all your specifications in handy. It should be in ready, then only we'll be filing the application. So the initial step, what we'll do is we have to begin with form 1. That we call it as application for grant of patent. So I will just take you to the Indian patent website. So first thing is you need to be aware of what are the fees which are prescribed to file a patent application. And as I mentioned, the patent office provides around 30 forms, and each form is used for a specific purpose that we will see. And some forms come with a overhead of fees, and some forms are of free of cost. So we need to know for which forms we have to pay the appropriate fees, and for which forms that are made available to file it as on free basis. So first of all, where we will do the filing, that is mandatory. That is very important to know. Actually, there are two types of filings that you can do. One is physical filing, and second one is the online filing. But nowadays, it is mostly it is done in online mode. So to file a patent application, we have to create an online account. So for that, the official website is ipindia.gov.in. So once you step into the main website of the Indian Patent Office, you can see a section called as a comprehensive e-filing. If you click on a comprehensive e-filing, you will be redirected to a separate page. And under this comprehensive e-filing section, there is a link called e-filing patents. You have to click on this, and you have to click on yes. It will redirect you to the filing page. So on the filing page, you can see there is a provision for you to create a user account for sign up. So once you have successfully created your account, you can directly log in with your credentials, that is username and password. and then initiate the filing process. But is it easy to create a user account? Yes, it is easy, but only mandatory is you need to have a digital signature. So I think everyone was pretty much aware of what is a digital signature certificate. We call it as DSC. So before creating the account, you need to purchase the DSC certificate from the issuer. I will suggest you one thing. I think you might be aware of it is eMudra. This is an agency in India which supplies the digital signature certificates. Again, in digital signature certificates, you have different classes. It comes as class 1 certificate, class 2 and class 3. So you have to buy for patenting. It is class 3 certificate is mandatory. So products, digital certificates. Yeah, buy a certificate. So the certificates are sold for individual persons as well as organizations. Since if you are filing it is on your own, you have to buy it on individual basis. And validity comes with minimum 1 year to maximum 3 years. So depending upon the cost, you can select your desired certificate and you can buy it. So this certificate, for this one, you have to also buy the FIPS certified token. If you don't have the token for the first time you're buying the DSC, then you purchase the certificate along with the FIPS certified token. So there are some simple steps are there, and there is an online support is also provided by eMudra. So what you have to do is you have to submit your KYC documents digitally, and within the 5 minutes upon payment of the fees, a certificate will be generated. And the crypto token, what I talked about, FIPS crypto token, in a blank token will be dispatched to you within 24 hours. So depending upon your location, I think within 3 to 5 working days you will receive it. After that, you have to there will be a guidelines will be given to you how to download the digital signature certificate into your token. So there will be some supporting the eMudra. While they are sending you the token, they will send you the supporting packages. You have to install the software in your system and then configure your token. And you follow the steps and try to download the DSC certificate and configure your digital signature. So once that is done, you have to create your user account in the ipindiaonline.gov.in website, and then it will ask you to it will ask you to integrate your digital signature certificate with your online account. So once that integration is successfully validated, your account will become active. So once it becomes active, you can just log in by using your username and password. Or else if you don't want to give a password, you can just give a username and make sure like you connect your DSC to this computer, and it will ask you the password of the DSC, that is like a pin. If you enter the pin, you will be able to log into your account. So once you log in, you will be having a provision to fill the forms in online mode, but it is not fully online. I will just explain you how to do it. So after logging in, you will get the interface that I will show you shortly. In that first form, what you have to fill is, that is form 1. This is the initial form that you need to fill. This form 1 is meant for application for grant of patent. So we will just have a glimpse of this form. So I am in the ipindia.gov.in website under subsection of forms and fees. So the first one is the first schedule fee. It consists of various amounts of fees that you need to be pay to the patent office with respect to each and every form. This you keep it aside. for your understanding. So as I told you, first we have to fill the form 1, that is application for grant of patent. We'll just have a glimpse of it. So this is how the form 1 looks like. This is what are the forms which we are able to see in online. This is just like a pro forma or a template. You cannot use it straight away. So what are the relevant information is there? You have to take it. Irrelevant information you have to strike it off, or else you have to prepare a similar kind of a form all by yourself. Or else you can make use of the online facility where you have to fill in few details, and the website will be generating the form electronically. That form you have to download it into your computer, and you have to process it further before uploading it into the account. So if you see form 1, and here you can see the use of Act 10 rules. So this is form 1, and it is telling see section 754 135 sub rule 1 of 20. So many sections, so many rules. So but it is, this form can be used for the main underlying meaning is this form should be used for used as an application for grant of patent, and this application can be filed with respect to different sections and different rules. It depends on the type of the application. So here for this presentation, I'm only discussing about ordinary application that is filed in India, but there are several other applications: conventional, PCT, divisional, patent of edition, patent of division. So many types of applications are there. But in the interest of the time constraints, I'm only discussing the ordinary application. So not only the form 1, what are the available forms in the patent office? All forms have multiple sections, are governed by multiple sections and multiple rules. So you should be aware of why you are filing the form, why you are with reference to which section and which rule you are filing that form, that the user needs to be aware of. So for your better understanding, what it is, I only highlighted the relevant sections in the PPT. So as we are interested in filing an ordinary application, so the relevant section is under section 7. So when you are preparing the form 1, you will have to mention like this is prepared with respect to the section 7. So this is the online version of the form. But I will just show the forms which I generated through online mode, and how it looks like. So this is the one. So you can make use of the online facility, and you can it will ask you to enter the details. Once all the details has been entered properly, it will generate a form. That form you have to download it. So what are the things which you need to enter in form 1? Mainly, since as the name suggests, it is the application for the grant of patent. So mainly it will have the applicant details. So if you are filing individually, inventor and applicant both are same. In case if you are filing via an organization, then applicant will be the organization. In my case, it is National Institute of Technology, Puducherry. You have to give the applicant name, what is the nationality of the applicant, and where is the applicant available, his complete communication address and country, as well as the state. So these are the mandatory details. Coming to next subsection, that is inventors. You have to list out all the inventors for this invention. So when coming to the inventor is a natural person, so we have to give his name and nationality and his communication address and country of residence and state. So like that, depending upon the number of inventors, you would be having a provision to add rows in the form. So you add a number of relevant rows and fill it with the relevant information. In my case, we have 5 inventors, so and 1 applicant. So applicants can be more than 1, and inventors also can be more than 1. and in some cases applicant and inventor both can be same. Next, it will ask you to give the title of your invention. So whatever the title which you have decided and which you have kept it in your form 2, that is the complete specifications or provisional specifications, that title you have to enter it over here. After that, there are fourth section is address for correspondence for the applicant. So or the authorized patent agent in India. If you're processing it on your own, then there won't be the involvement of any patent agent. So the applicant is only the responsible for communicating with the patent office. So he has to give his communication address followed by telephone number and email ID. Actually, email ID is very important because all the communications with the patent office will be written will happen via the electronic mail format. And section 5, these are the details of related to PCT filing 5 and 6. So these sections are comes into picture when your application type is other than the ordinary application. So whatever the relevant details that you need to enter, irrelevant sections you can leave it as a blank. So with respect to the ordinary application filing, these are the preliminary mandatory details that you need to enter in the form 1. And it has to be signed, but don't sign it in the declaration. This declaration is meant for some other case that I will let you know. Actually, the form needs to be signed at the bottom. So after the section 10, so here there is a column called signature. So whoever is signing, their names should be listed at the below, and what is the relation of this person with respect to this invention, that also needs to be entered. In my case, I am the inventor, and there is no patent agent involved in processing my application. So I'm only handling the I'm only acting as an inventor, and I'm only the authorized person for my applicant. My applicant is NIT Puducherry. So on behalf of NIT Puducherry, I am the authorized person. So I am only filing the patent. So I have given my details over here. And whenever you are signing, you have to enter the relevant date. So first you have to submit this form. So once you have submitted this form, along with that, after submission, it will ask you to pay the amount. So we will see in the first schedule, as I told you earlier. So what is the amount for filing form 1? So if you open the first schedule, here on top you can see for e-filing and for physical filing. So we are pretty much interested in e-filing, but for your understanding, I will just quote the prices for both. For physical filing, you have to go to the patent office and you have to file it manually. For e-filing, you can do it anywhere from the comfort of your home. You can do it. So again, the prices are pretty much different for different categories. Here there are two categories are mentioned in the form. So one is the natural person, a natural person alone, or else a startup company, or a small entity or entities like MSME kind of industries, or else the educational institutions. This is the first category. And the second category is others, who are not in the natural person, not in the startup, not in the small entity. It may be a large entity, or not in the educational institution. Or whoever irrelevant of all these four sections, they all comes under other section alone. That is important. Or else any of these four persons, that is either natural person, startup, or small entity, or an educational institution with the other person category. So those all comes under the second category. So there is a price difference between first category and the second category that we will see. So far we are discussing about only the form 1. So coming to the form 1, so this is the column which is showing the number of the relevant form. So that is column number 3. So in 3, the form number is 1, and here you can see the description, application for patent under sections. So sections are listed. We are interested in filing under section 7. So if you see, the initial price is 1,600 rupees for the first category of people, and it is 8,000 rupees for the second category. So amount is in rupees. So this amount you have to pay initially, and this is a base fare. Actually the 1,600 or 8,000 is the base fare. For time being, I'm only interested in the category 1. Why? Because in the interest of the audience for today's session, I think majority of the people are from falls under the first category, so I will discuss only the first category. So we have to pay a fee of 1,600. That is a base fare for the form 1. Again, in the form 1, it will ask you how many pages are there in your specification. That specification is a complete or a provisional. So depending on that, the system will generate a separate price for the form by taking into the consideration of form 2, that is your complete or provisional specifications. The patent office will allow up to 30 pages of your specifications. So anything beyond the 30 pages per sheet will be charged with a rupees of 160 rupees. That's it. And as I mentioned you earlier yesterday, patent office will allows you to draft your claims up to 10 in number. So any additional claim that you're making in support of your invention, so each subsequent claim in addition to 10 claim will be charged at a price of 320 rupees. So there are some other prices for mainly meant for chemical patents, so that I'm not touching upon. So you can understand like this: for form 1 you have to pay 1,600, and by that is a base fare. By taking into consideration the form 2, actually for form 2 here it is mentioned as no fee. But it depends on the number of pages in the specification. Anything more than 30 will be chargeable. 30 pages will be chargeable at a rate of 160 per page. Even the drawings, complete specifications, everything comes into the picture. Everything, each and every page will be counted, even including the cover page as well. So there is no exemption. And claims will each anything above 10 claims, each claim will be charged about 320 rupees. So while filling the form 1, as we have seen here in the details, while filling all these forms, all these entities, here in the actual form it will not show what are the number of claims or number of pages in the specification, but the computer will take that information, but it will not populate in the actual form 1. So what it will do is it will calculate and it will show you the final amount. That amount you have to pay as per the first schedule. So 1,600 plus additional amount. So that completes the form 1. And form 2 you're filing under section 10 and under rule 13. If you see in the first schedule, it is mentioned as no fees for both the categories. And same thing again, it is repeated for each sheet in addition to 30, 160 rupees, and each claim in addition to 10, 320 rupees. So separately again you need not pay any amount for form 2. Form 1 and 2 are combined together. So moving on, I'll just close all these things unnecessary. Okay, now we have seen form 1 and form 2. Next we have to file form 3. Whatever the sequence of forms that I'm discussing right now, these all are mandatory forms. You should not skip any of the form. So if there are any optional forms, I will straight away mention it to you. So form 1 is over, form 2 is over, form 3. So form 3 we call it as a statement of undertaking, and this has to be filed under section 8 and under rule 12. So what is this statement of undertaking? We'll just see. We will see the actual template of this form from the official patent office website. So it is nothing but it is just asking you to give an undertaking, why it is undertaking and what it is meant for. Actually, the patent is generally filed to claim a territorial protection, means your invention will be legally bounded and protected within the territory. So if you're filing in India, the rules are applicable and your patent invention is protected within India, but it won't be enforced in other countries. So what if your application is having a huge commercial value, then you may file it in multiple countries to claim the protection. So the patent office also very much interested to know, as per internal policies, whether you have made any of the simultaneous patent filings in another country with respect to the same application that you have filed in the home country. So those details you have to mention, and this information you have to give for every 6 months within the once you have filed, within the 6 months you have to give this information. Even if you have not filed, I think patent office is asking for every 6 months until the grant of the patent, you have to file this form with this timeline. So if in case if you have filed outside India, you have to enter the which country you have filed, what is the date of application, and what is the application number over there, and what is the status of the application, and if it is published, what is the date of publication. If it is granted before Indian patent, then what is the date of grant, and some just a declaration. This is just a template, and I will show you my form tree for your understanding. Actually, in online mode, form tree is currently not available for automatic generation or electronic generation. I don't know why it is not available. Patent office is asking us to prepare the form tree. So that's why I just prepared. I have taken this as the reference pro forma available in the website. And then what I did is I have prepared a document in MS Word, only the relevant things. So you should not skip any of the rules and sections which are mentioned in the pro forma. So you have to if you're preparing any forms on your own, you make sure like you write all the relevant rules, sections and everything. So these are all the information is taken from the pro forma itself. Only thing is, since I have not filed anything in any other country, I kept everything as not applicable. So and then you have to sign it. So sign, write your name and what is your relation with the application, and you have to submit it in online. So whenever you are submitting it, you have to write to which office you are submitting. Actually, I forgot to mention one thing. Previously we saw form 1. Once it is filed, once it is prepared, then what you will be doing is it will show the fees. You will be paying the fees. Once the fee is paid, an application number will be generated, and depending upon the details what you have entered, like your communication address, from which state you belong to, so the nearest patent office will be allocated. So if you're filing in southern region, all the filings will be assigned to the Indian patent office situated at Chennai. In the northern region, it is New Delhi. In the east region, it is Kolkata, and the west region, it is Mumbai. So you will get, once you submitted and paid the fees for the form 1, you will be getting the official application number. So by using this number, you have to quote it in the subsequent forms, and then you have to file your you have to complete your filing procedure by uploading all the relevant set of documents. So once you file the form 1, then you will get the number. That number you use it and upload the complete specifications. After uploading the complete specifications, you need to upload supporting forms. Hello. Yeah, participants, please mute your mics. So once where I am, yeah. Once you have submitted form 1 and form 2, then you have to fill all the relevant forms for processing of your application. And while filling your forms, you have to make sure like you have to enter the application number as well as on which date you have filed your means on which date you have paid and filed your complete specification, that we call it as the date of filing. So like that, and at that time only you will come to know to which patent office it has been assigned. Actually, by seeing in the application number also you can tell. 2021 is the year of filing. 4 is the region. 4 means it is a Chennai office. So 1 stands for Delhi, 2 stands for Mumbai, I think, 3 Kolkata, 4 Chennai, and after 4 there is a 1. 1 stands for ordinary application. And the remaining 6 digits based on the odd serial number in which the applications were filed in that year 2021. So this is a convention, numbering convention for the application number. So these two are very important: application number and date of filing. So we have seen form 3. That is statement of undertaking. Mainly you are informing the patent office whether you have filed any international applications or not. Next comes the form 5. The form 5 is called declaration as to inventorship, and this has to be filed under section 10 of 6 and under rule 13 of 6. So what is form 5? It is saying like declaration of inventorship. So let's see the pro forma first. So this is a pro forma available in the website. So for the rest of all these forms, you can generate it electronically while logging into your account, or else if you want to prepare manually, you can prepare and upload it. That is as per your choice. So this is a basic pro forma. So I will just open my form 5. One more thing, not it's important to note that 1 and 2 I have mentioned symbol like rupee symbol because price is involved. Form 3 is free of cost. Next, form 5 is also free of cost. Now we will see how to file a form 5. So in the online mode, you have to click select form 5. It will ask few details. You enter all the details. So what details it will ask to generate form 5? Mainly it will ask who is the name of the applicant. You have to enter the name of the applicant. Actually, I think you need not enter the name of the applicant because while clicking on form 5, it will ask whether you are filing for an existing application. Then you have to enter your application number. That's it. Once you enter the application number, it will populate available information that is fetched from the real-time server, a server of the Indian Patent Office, and it will ask you to enter other details. So I think in form 1, if you remember, you have mentioned the inventors list. I think this will also, to the best of my knowledge, these also things will be populated automatically. Only thing is it will ask you to verify once again at your end, and if there are any corrections which you want to make, you can just make it, and you have to save it, and then you have to generate it. So only thing in this form 5 is only meant for declaration by inventorship. This is a declaration in the sense you are saying like for this application of the patent I am the true inventor. So this is very much useful for in those cases where applicant and inventors are different from one another. Even in the cases where applicant and inventor are same, but it is mandatory to file form 5. Means you are self-declaring that you are the actual inventor for the invention, and there is no other person involved in this invention. What are the persons listed only they are responsible for your invention. And when you're filing this form, you have to enter the date, and under the signature field you have to sign it, and then you have to give your details. Actually, when you're generating this is an online mode, you will be checking all the relevant details. Once it is fine, okay, or else if you want to make any changes, you can edit straight away in the online mode. Once everything editing is over, you can preview the form. So once if you have previewed and if you're satisfied with the form, you can download it. After downloading, what you have to do is here you have to insert your signature. This I have done in Adobe. You have just import your signature and you have to fill these fields, the name of the authorized signatory, and then after that you have to save it, and this form you have to submit it. Because when you are generating it online, it will only fill the data, but your signature won't be present on the form. So mandatory, as per patent procedure, it is mandatory for you to download the form, and as per your convenience, you can sign it manually using a ink pen, or else you can just put your scanned version of your image, signature image, you can embed in the document, and then that document you can save it by using the Adobe Acrobat tool, and that PDF version you can straight away upload it in again in interface, and then you have to submit it. If you're signing it conventionally, then you have to scan your document again, it should be in the PDF format. That PDF format you have to upload it, and at the end, and you have to sign it only near the declaration. So sorry, after you have mentioned all your details, you have to sign it at the bottom. And it is also asking declaration for convention country. As I mentioned, each form is filed for different purposes, different types of applications. So if you are filing for the ordinary application, that is what we are discussing for, you have to sign it under the second subsection of the form 5. Remaining sections, wherever it is asking to sign, you please don't sign it, because those all are inappropriate. Here this is a watermark, you can see like this is electronically generated. So if you are generating this form online, this watermark will be applicable to your form. So this form is also free of cost, you can file it with relevant details. So form 3 is over. So once you have filed everything, your application will be in the patent office for a minimum of 12 months. So after 12 months, it will publish automatically. Then it will go for examination upon your request that you are eligible to file after the expiry of, I think, 24 to 36 months, 24 to 48 months. Within that time, you have to file. If you are filing for, if you are making for a normal application. But if you want to fast track your application, if you want to speed up the process of grant, and you want to get your grant within a year, generally it will take, ordinary application, it will take a minimum of 2 to 4 years to get a grant. But there are some special provisions provided in the Patent Act where if you fall under those provisions, you can fast track your application, and you can able to get a grant within a year. So further, what you have to do is, as per the convention, once you have submitted the patent specifications to patent office, it will be in the closed form. They won't process it anything. They will if the application has to be processed first, it should be published and it should enter into the public domain, that we call it as publication. In the ordinary mode, it will take 12 months to publish automatically, but if you just want to speed up the process, you have to file the request for early publication, and this request should be filed in form 9. So this request in form 9 you have to file, and this is based on section 11A of 2 and rule 24A. I'm not going much into sections and rules. If you're interested, you can just go through the rules and sections of Act and rules for better understanding of this one. So as of now, form 9 is meant for, if you want to make your application to publish immediately. So application will not be processed unless it is published. So once it is not published, it is not yet moved in the office. It will remain in the desk. So in order to make it publish, you have to file Form 9. So we will see the Form 9. So this is a pro forma of the Form 9. This is a simple form. I will just show you an example of my form. This is a form. The only thing is you're requesting it for publication. Request for publication. This is again, you can generate it in online, then download it, then put the date and signature, and after that save it, again upload it. So after you upload this form, it will ask you to pay the fee. This form involves fee. It will ask you to pay the fee. Once the fees is paid, it will be processed for publication. So in the first schedule, we will see what is the amount for publication. So here you can see this is Form 9, and this is for request for publication under section 11A2 and Rule 24A, and for the first category it is 2500 and the second category is 12,500. So this is very much huge. So and there is a recently last year I think Indian Patent Office has reduced the fee to increase the filing of IPR in India. So that's why in the first category there is a lot of exemption given. It is only 2,500 rupees. So once you pay the fee, your application will be processed and then it will be published. So where it will be published? It will be published in the Indian Patent Journal. So how to access the journal? So that we will see. Again, I'll go back to the home page, and here you can see journals. In journals, this we have three categories: patent, trademarks, and geographical indications. So we are interested in patent journals, so click on patent. If you click yes, you will get the journal publication list. Every week on Friday, Patent Office will roll out a new issue of the journal. So you can see here on 24th April, we got an issue. Actually, today is also a Friday. Maybe at the evening at 5 o'clock, you will get today's issue. That is, today's date is 29th, right? So last Friday date is 22. So we have the 22nd April publication. And it is divided into 4 parts: part 1, part 2, part 3, part 4. So if you open part 1, that is the first volume of the journal of that week. So if you see here, this is official journal of the Patent Office, and for each issue there will be a number followed by year. In this 2022 year, this is the 16th issue. As I mentioned, every Friday you will get an issue, and this is a date. This is the publication of the Patent Office. So in this journal, your application will be published. So you see here early publication of Delhi office, early publication Mumbai, early publication Chennai, early publication Kolkata. Actually, I told you earlier, normal publication, it is actually 18 months. I wrongly mentioned it's 12 months. Please correct yourself. It is 18 months. If you are not filing the request for publication up to 18 months, your file will not be touched. It will not be processed. After 18 months, automatically it will get published. So if you want to fast track your application, you have to file a request for early publication. So these are the number of this is a page number. So if you have filed in the southern region, it will be associated with the Chennai Patent Office, and after filing, I think within 1 month, at any point in time, within the 4 issues, it should come. But if it due to unforeseen circumstances, there is a possibility to get delay as well. but more or less within 1 month it will publish if you do if you file a request for early publication. So every Friday you can download this document and check whether your patent has been published or not. So a publication will be, there is a separate format for that one. So in each page contents related to one patent will be printed. Only this is the, we call it as a publication document. So I will just show you my published patent for your reference. Yeah, it's just a single page. So you need to know what are the contents. This is the actual format of the patent publication. Now we will see what are the contents. So first of all, it will have an application number and the publication date, and it will also mention what is the date of filing of your application and what is the title of your invention. After that, you will be having the name of the applicant and the name of the inventor. And coming to the details of your invention, only the abstract will be published. So as I told you earlier, abstract you have to write it within 150 words. Those within 150 words, whatever the abstract you are giving, this will be only made to the it is placed for the public access. And at the bottom it will tell a total number of pages involved in the complete specifications. So in my specifications 55 pages are there and number of claims are 11. So if any end user, if he wants to go have a look into your invention, the actual process is first he will come to this publication document and he will read only the abstract. If he is interested to know about your work, then he will able to he will access the complete specification document comprising of number of pages that is mentioned at the bottom of the published page to understand your invention in detail. So I will show you how to download the specifications, copy and other documents how to from the patent office, that we'll see at the end. And what are the other major things available in this form? Other one is there are some codes assigned to your file from the patent office. Initially, whatever the things I have highlighted, all this information has been from the user point of view. You have given information and the patent office has published. So beyond that, patent office will add some classification codes. There's a standard way of categorizing the inventions with respect to the field, subfields, and so on and so forth. So depending on those classification schemes, there are some code words assigned. So relevant code words for your application that patent office will identify and it will give it in the, it will list it in the publication document. Based on these codes only, they will try to search for any prior art associated or that closely matches with your invention. And if at all, if it matches, then they will give you a chance to prove that it is not the one which is currently in the prior art. You have to defend yourself. Upon defending everything, then you will be granted a patent. If you're not able to do so, then your application will be dropped. So these are the details of publication. So I'll close it over here. Yeah, we have seen till publication. So once it is published, again, if you want to process it further, it has to go for examination. So you have to request for examination. If you're filing in a normal mode, then Form 18 is applicable. If you have filed in fast track mode, you have to file Form 18A. Both are meant for examination only, but Form 18A is meant for expedited examination. In this expedited examination, there are strict timelines. So soon after publication, they have to do the examination at the earliest, and they have to give you the examination report. That we call it as FER, that is first examination report. It is also called as FSO. In olden days, they call it as FER. Now it is called as FSO. That is refers to as a first statement of objections. Means patent office will raise some objections. You have to defend those objections for the grant of patent. So what is Form 18A? It is for expedited examination of application for patent, and it has to be accompanied with appropriate evidence, because if you want your application to be put it in fast track mode and examination be completed at the earliest, then you have to file it with appropriate evidence, so whether you are able to meet the requirements as per the act and rules. So if it is in the 18A, you will be filing application as per section 11B and 24C. In these sections, there are some guidelines which define the applicability under the fast track mode. So we will just have a glimpse of 18A form. Yes, this is a form 18A. This is a pro forma available in the website. Now I'll show you my form. I think I have not downloaded my form. No problem, I will show you how to download it. So you just go to patent search. If you know your application number, you can enter. Even after you have filed your application, if you want to check the documents and status, you can use this search engine. And this search engine also can be used to check any prior art by using some keywords that match with your invention. So those all can be done. So here mine is anyhow granted, you will get a granted kind of thing like this. So you can go to documents and you can see the list of documents filed. Yeah, this is form 18A. Yeah, this is form 18A. We will see its contents very quickly. Form 18A, request for expedited examination. So once you log into your account, you just click on form 18A and it will ask you the application number. You just enter the application number, then it will populate automatically the details. You just go through the details and check whether the applicant name, address and nationality were mentioned properly or not, and then it will ask you to tick an appropriate box under which category you think you will fall and you are eligible to file an expedited examination request. Since I am from National Institute of Technology of Puducherry and my applicant is NIT Puducherry, and this is a central government organization and the applicant is an institute, it is established by a central or a provisional or a state act. It can be my institute is established under a central act, but there is a state act as well, or a provincial act, so I don't know what it is. So that is fully owned or controlled by the government. So if Like that you have to select. Suppose if you are an applicant, you have newly established a startup company, then you have to tick this appropriate box. And what is the definition of startup, that also you need to be aware of. In this 18A, I have referred this section, right, 11B and 24C. If you go through those legal act and rules, there is a limit which is set for a startup. I think it should be less than 5 years. The startup company should be incorporated less than 5 years, and the annual turnover, I think it should not exceed 20 crores. So those are eligible for the startup category. And if you think, sorry, I'm getting a disturbance. Participants, please mute your mic. Hello. Host, can you please mute the participants? Am I audible? I think I am also being muted. Hello. Hello.
Yes, sir, you are audible.
Okay. Thank you. Yeah, if you're a startup, you have to enter in the startup category. And if you in your inventors, if there is at least one female candidate, then you are also eligible for fast tracking your application. So you have to select the relevant section for which you feel like you are deserved to be eligible for the fast track application. You have to select that one, and then what you have to do is, and it will ask you to submit documents in support of as an evidence of eligibility in order to avail the benefit of expedited examination. So in my case, my applicant is an institute established by the Central Act, and for that what they are saying is patent office is asking any document as evidence for the eligibility. So for that, what I submitted is a Gazette notification. So that is also given by the central government. So on this evidence, 18 evidence, yeah. So this is a Gazette notification of India. In this notification, the Ministry of Law and Justice, they have published an act, the National Institute of Technology Amendment Act 2012. So in this, they have mentioned like National Institute of Technology Puducherry is a government organization. So this Gazette notification becomes the eligibility document. Similarly, if it is a state university or any other thing or any other government organization, so the relevant ministry or a governing body will be having some official documents that you can collect it, and you can use it as evidence. In case if you are in your group of inventors, if any at least one female candidate is there, then also you are eligible. Then related to that female candidate, you have to upload the personal identification KYC documents. And lastly, you have to generate your form. After generating your form, what you have to do is you have to download it. After downloading, you have to put the date, sign it, and then you have to save it. After saving it, you have to upload it along with the evidence. It will ask you to upload for signed form 18A along with the evidence. So 2 copies you have to upload, and then you have to submit. So after submission, what will be happen is your request for expedited examination will be taken into consideration, and the controller will assign your specifications to an examiner. That examiner will go through your application, and then he will also conduct a search in the public domain, and he will check whether any prior art is matching with your invention. And after a detailed case study of your application, he will come up with some list of objections, suggestions, and so on and so forth. And everything they will include in one document that is called as FER, First Examination Report, and that report will be mailed to you at the earliest. I think soon after filing, within less than 3 months. Within 3 months of filing this form, your application will be examined and a report will be generated, and that report you will be getting it. So we will look into those details on the subsequent slides. So till now we have filed Form 1, Form 2, Form 3, Form 5, Form 9, and Form 18A. Next form in this series, we have filed 6 forms. The 7th form is proof of right. Actually, this proof of right is not necessary in case if applicant and inventors are same. It is only necessary if applicant and inventors are different. So in my case, applicant is a non-natural person, that is, it's an organization, and inventor is a natural person. So in my case, it is a proof of right is necessary. Why? Because how the applicant has got the right to file an invention in his name if I am the inventor. So since you are working in a research organization, then the IPR will be maintained by the organization itself. Whatever the research and output that is coming out of that organization, it purely belongs to the organization. However, some benefit of credit will be given to the researcher. So that's why in the patent file you have the documents, you will be having a section called what is the name of the applicant and who is the inventor. So in case if you're filing on your own and the research you have done at your own premises, then you can file own application, and in that case applicant and inventor will be same. But in the normal case, applicant and inventor will be different. So applicant is going to maintain the IPR and it is going to file a patent. It has to do so only when the inventors has assigned the right to the applicant. So patent office will always look for a document whether the inventors has given the right to the applicant or not. That's why they will ask you to submit a proof of right. So what is this proof of right? So it is required from the inventors by 2 ways. Patent office allows in 2 different ways. One is given endorsement in the appropriate paragraph of Form 1, or else any document that is a memorandum of understanding between the applicant and inventor, that we call it as an assignment, given by the inventors in favor of the applicant, and that is duly authenticated. Means I think it should be notarized legally, then only it is legally valid. So it can be either a assignment or it can be very much simple form. You have to sign only at the relevant section in Form 1. So earlier I mentioned you one point in Form 1. So Form 1 is generally used for we have seen like it is used for as a request for application for grant of patent. So in this application, you are requesting the patent office for the grant of patent. So in this form at the bottom, you have a section called declaration. Earlier I told don't sign near this declaration. If you're filing Form 1 exclusively for Form 1, you have to sign at the bottom over here. If you are using Form 1 for filing as well as declaration by the inventors, then you have to sign at this designated position as well. This declaration is sufficient. Here you have to enter all the names of the applicant, and you have to mention we are the true and first inventors, and we declare that applicant is our assignee or legal representative, and who are the inventors are there. All the inventors need to sign. So in my case 5 inventors are there, so 5 inventors has signed. So now a proper right has been assigned to the applicant, so that this serves as the proof of right document. So it is not applicable for all the applications. So if it is appropriate, you have to file it. Next, we have to file Form 28. This is to be submitted by a small entity, startup, or educational institution. Why? Because in the first schedule, if you see, I have discussed two categories. One is natural person, startup, small entity, or education institutions, and other one is others. So you have seen the price difference between these two categories. In first Form 1, it is 1600 and 8000. Next Form 2, no fee. Form 3 is also no fee, as we have seen. Next Form 5, that is declaration of inventorship, that is also no fee. Request for publication, we have seen 2500, 12500, and expedited examination we have seen in this case 8000, and here it is 60,000. So if you compare these two categories, a lot of price exemption is given to the first category. So for that purpose, what patent office is asking is, whenever you're submitting any form after making a prescribed payment, they want to know whether if you have paid in the exemption category, in the first category with a limited fee, you have to support that all those forms with the form number 28. So form 28 is mandatory. Wherever any form you're submitting that involves a fee, you have to submit a form 28. Again, in this form 28, you have to attach the evidence of eligibility. So earlier for form 18A, for expedited examination, you have attached one evidence. So the same evidence, you can use it as appropriate evidence document. You have that 18A document. The same evidence you have to use and attach it to the form 28. So this is the template for form 28. Unfortunately, I don't have form 28 in my patent application because these amendments came recently, but before that I have filed. So for me, there is no stringent requirement of filing form 28. That's why I don't have at my end. So this again, you have to enter the patent number when you are logged into your account. Then it will automatically, all the relevant sections will be pre-filled automatically. Then you have to download and you have to tell which form you are submitting as an evidence, and you have to sign this form and along with the evidence copy. In 18A, what evidence you have used, same that evidence you can use it and you can submit it to all the forms. This form 28, on top of it, here you have seen, right, in form, what are the forms involved in the payment: form 1, form 2, form 9, form 18A. So while you're forming those forms, you have to accompany form 28 as well. Okay, the next form is form 26. This is nothing but authorization of patent agent or any person in a matter or proceedings under the act. Sorry. Yeah, we will see what is form 26. In case if you are processing your application via a patent agent, then you have to file this form 26. Again, this form is not available with me. Why? Because I have not hired any patent agent. I have filed it on my own. So in that case, this form can be skipped. In case if you wants to file via a patent agent or any other person who wants to go through all the details and support you for a grant of patent, you can nominate anyone, but whoever you are nominating it, you have to have an agreement between you both, and that is called power of attorney. You have to make it, and that power of attorney should be submitted with form 26 as an evidence. then only he can communicate on behalf of you and take part in the grant, take part in the all the proceedings for the grant of the patent, as well also for maintaining the patent. In between, you can change your patent agents whenever you want, but however, you have to priorly inform to the patent office. Next, next is the Form 8. Form 8 is used for request for mentioning of the inventor in a patent application. So we'll quickly see what is this Form 8. It basically means like once the patent is granted, you will get a certificate called Patent Grant Certificate. I will just show it to you. The certificate looks like this. So what are the fields here? So this is a patent certificate, and a new number will be assigned to you that will call it as patent number, and your previous application number will be listed, and the date of filing will be listed, and then the patentee name will be given. But in the certificate, generally they will not mention the name of the inventors. They will only mention the name of the applicant. But in the certificate, you want the inventor names also to be mentioned. Then you have to tell to the patent office, like in whatever the communications you are doing, you include both patent applicant name as well as the inventor name. So for that purpose, you have to file Form 8. Otherwise, all official correspondence will be made only with respect to the applicant, not with respect to the inventor. So if you want to make the correspondence with respect to both applicant and the inventor, then you have to file Form 8. Then in the grant certificate, both the patentee name and the inventor name will also be printed. So this is the only significance, and this form also comes with a fee. So this is Form 8, right? So Form 8, it is 800 rupees. In the higher category, it is 4,000. So I have an example of that form. So this form also can be generated online. Only thing, it will take the inventor details. If you enter the application number, it will take the it will generate all the details, and you have to just check the details and confirm it, and then download it. After that, you enter the date and sign it, and then upload it. So once uploaded, patent office will take care of mentioning the details as appropriate. So we have seen up to 10 forms. Now we will see the miscellaneous forms. That is, first form is Form 30. The patent office says use Form 30 when no other form is indicated to use for any activity. So in the life cycle of the patent, I was told till grant you have to process some requirements by using different forms. At any moment, if for processing or for interacting with the patent office, if no specific form is mentioned, then by default you can use a Form 30, and you can write whatever you want, what type of communication you are doing, everything you can write and state it here. One example I will tell. Once it is examined, your patent, then you will get FER report. After writing FER, you will submit it. Then the controller will call you for hearing. And once he calls you for hearing, you have to inform the controller that, okay, since you have called, I will appear in front of you to clarify the objections. So that one you can inform via Form 30. So that we call it as intimation. That is this form. I will show you. So if any form is not specified for any particular task, then you can by default use Form 30 to process the task. So Form 30 is very simple. You click on Form 30, only the preliminary information, whatever it is required, it will fetch. That is name of the applicant and address. Application number will come. And for what is the purpose of writing this letter or communicating to the controller? So if it is relevant to any section or any kind of rule, those things you can mention here. In here, my purpose is I want to inform the controller that I am attending to the hearing. He asked me to come for hearing, so I'm giving a reply like I will come to the hearing. As per the Patent Act and rule, it is defined under rule number 28 of 4 that once anytime if you receive a notice from the controller, you have to respond it. So that rule is defined in rule number 28 of 4. So I gave reference to that rule, and the purpose I written like I am notifying the controller priorly that I am going to attend the meeting, that is hearing. So you can write some brief details, and then you can sign it, and then you can put the date, and then you can file it. So along with that, if you wish to add any more information, but in the form you are not able to fit anything, then you can write a separate cover letter as well. This is not mandatory, but there is an option while using any form, so you can also write cover letters wherever required. So form 30, it has to be used when no other form is prescribed. Next we have form 4, that is for request for extension of time. As I mentioned you earlier, it is patent is the entire process of patent is strictly timelined. In case if any delay is going to happen or it is happening because of from your end, there is a provision to make a request to the controller and to give some additional amount of time. So for that, what are the stages at which you can request for extension of time? So all these are mentioned in the rules and sections, but however I'm not going to list list all those things due to time constraint, because mostly people will not fall into this category, because it is always advisable to follow the stricter timelines. Due to unforeseen circumstances, if you are not able to process in time, it is always advisable to intimate to the controller and file the form for with the requisite fees. And where that while processing which task you are getting the delay, for each and every stage there is a separate section, separate rule and separate fee, so that you have to take care. And another one is the petition. So this petition is also it is a special type of form. It is required to request for condonation of delay or else any irregularities in the procedure. What are irregularities? I will tell you. Here for one example I told, we have to submit proof of right. This proof of right, patent office will give you a timeline of 6 months from the date of filing. Within the 6 months, applicant is responsible to submit the proof of right. If he is not submitting within the 6 months, then that becomes an irregularity, because you have skipped the appropriate timeline constraint. So that's why it will be you have deviated from the timeline. However, the deviation is not so critical. It's just, but there are some instances where you should not skip the timeline. If you have skipped the timeline, your patent will be treated as abandoned, and it will be, they will think like the applicant has withdrawn from his end. So once it has been abandoned, it cannot be turned into further processing. Again, you have to do all the process right from beginning. So for critical stages, they will drop the patent application. But for non-critical cases, what they will ask to rectify those things, you have to file a petition. Of course, again, for petition, depending upon the type of mistakes that you have done, they will charge you dynamically, and then you have to pay the requisite fee and file the petition. So these are the forms we have seen. And quickly what I will do is I will just give you an overview. So you have filed the application, your patent application, with all these requisite forms which I have disclosed right now. And once after filing, what it will be doing is it will go for publication. After publication, once it is published, it will be notified in the patent journal. So as we have seen, it is published in the official journal of the patent. After publication, it will go for examination. In the examination, after examination, they will issue the first examination report. I'm just showing you a glimpse of the first examination report. This is the first letter page, first page of the letter. So when it is generated, the date will be mentioned here, because this date is very important. From this date, the actual timeline will start for you. So application number will be written, and this is the examination report. So they will examine your specifications thoroughly, and they will give a report. So what are the contents of examination report, that we'll see very quickly. So this is application number, this is a filing date. Oh, sorry. So we have overall summary. So here they will check whether inventor step in the claims is available or not. So if it is not available, they will tell not available. Next, industrial applicability, there or not, they will check. So yes, here industrial applicability is there, that's why they kept yes. Next, non-patentability, whether that is called as section 3. Section 3 mainly defines what are the things under which a patent cannot be granted. So whether any claims is falling under that category or not, they will check. Whether the disclosure is sufficient or not, or still lacking any details or not, those things they will check. And finally, what they will do is they will do a public search, and they will identify few documents, and they will tell like these documents are matching with your invention and they are acting as the prior art. Those documents mainly they will take into consideration the patent literature. Next, they will also check for non-patent literature, and they will give you the details of the document. This is a document. Sometimes it may be your published document also. So in my case, this is my published document, research article. But however, this article is not very much linked to this invention. If it is linking with the invention, then your patent will not be granted, because even though if it is your article that has entered into the public domain, anything in the public domain, a patent will not be granted. So you have to be very careful. If you have a point of filing a patent, don't try to publish your patent first. After publication, first after filing the patent, try to get the what we call the filing date. After getting the filing date, then try to you can publish your paper. So then what they will do is they will do a detailed check, and they will tell inventor step is not in your design, in your invention. Why? Because since these documents which were identified, they are acting as the prior art, and due to that your invention, there is no inventor step in your invention, like that they will tell. And they will write a brief description of all those documents. They will list it over here. What are the documents which they feel like matching with your invention. So they will raise their questions. Only thing is you have to defend like with these things are different when compared to my invention. So you have to defend in where you have to defend, you have to write a reply to them. So in that reply you have to defend. So next what they will tell, this is section 3K. Section 3 of the Patents Act mainly deals with some constraints under which a patent will not be granted. In that there is one such a constraint, that is K constraint. What that K constraint will say is any mathematical methods and algorithms is non-patentable. So anything you're running on software or mathematical method or algorithm, those things are not patented. So they are telling like these claims what you are writing, they are involved some it seems to involve a mathematical method or algorithm. So we feel like it is matching under section 3K, and hence we are not able to grant the patent, like that they will tell. So only thing is you have to clarify to their raised objections. Next section is sufficiency of disclosure. More or less these sections will remain same for all the patent exam applications. the examination report more or less remains up to few sections, and wherever it is not matching, they will write their explanations. So clarity and conciseness is not there, disclosure of sufficient information is not there, and very important thing, sometimes they will ask you to supply a working model or a prototype or a sample that illustrates the invention. So in this working prototype should be in the form of a hardware, so you need to be very much careful. Don't try to write a uh, uh, don't try to file any application that contradicts for practical implementation. So anything which is practically implementable, that only you have to file, because sometimes if you fall into this one, if they may ask you to provide a model or a sample, but this won't be the part of your complete specifications. This is only for their better understanding and to check whether it is practically implementable or not. So those things they may ask. And if any clarity and conciseness is missing, or the use of some words, like I use some words like further, comprising, further, they are telling like vague and indefinite, it should be deleted. Like from their point of view, they will give their suggestions. And other requirements, if you in this section, what they will do is if any abnormalities are there and anything, then they will just mention it to you. And these are formal requirements. These formal requirements means I didn't submit a proof of right, so please submit it. In some cases you have not signed, the signature is not available, so you please sign it. So application number in drawings is not mentioned, you please mention it. Like that, if any some irregularities are there, they will tell it. And they may ask you to re-upload few forms if they find any corrections. And then at the end, what they will do is, here this is very important, they will give the last date for filing response to examination report. This date will be exactly 6 months from the date of generation of this report. And your patent will be examined. If you have filed in Chennai, it will be examined in other locations. In India, we have 4 patent offices. So if you file in one patent office, it will be assigned to any of the 3 other patent offices, and a controller will be allocated for you, and this controller will remain the same until your patent is granted. So he will only look after your file whether to grant or drop your patent. So within this 6 months, you have to, what you have to do is you have to file the response. So how you have to file the response, I will just walk you through the reply letter. So this is the reply letter. So it just begins with a cover letter. So after the cover letter, just I think most of you have a good experience in writing research articles. Once you have written the research article, after review you might have got the comments. So again, you are making modifications and writing a response letter to the journal, and you are telling how you have taken those comments, how you have addressed those comments, and how you have modified your comments. Those things you can write as a cover sheet. And I will just highlight the important things. These all things are not mandatory. I will just go walk you through the important details. In my FER, they told like 2 patent documents are matching with my invention, so they have highlighted the documents. And coming to non-patent literature, they told like one research article is matching. That one research article is nothing but my article itself. And they told like these are the contradictions. So document 1 is matching with your invention, document 2 is matching with your invention, document 3 is matching with your invention. Like that, they will just give you. So what you have to do is uh, you have to prove it that prior art whatever they have disclosed is entirely different from your invention. So how do you prove it? First, what you have to do is you have to write a brief summary of your present invention, that means your invention. And then what you have to do is, whatever the documents they have identified, you have to thoroughly read all those documents and try to understand what they have implemented. And after your brief understanding, you have to write a brief summary report. So this is a brief description of first document. I'm just skipping all this content. Next, brief description of the second document. So whatever they have written. Third, again, brief description of the third document. So they have, in my case, they have given 2 patent documents, 1 research article, so total 3 documents. So I have briefly summarized each and every document. The next step is very much important. So you have to prepare a comparative statement, a table like this. So this is a comparison between my invention and the document 1. So on the left hand side, present invention and the application number, and right hand side is the document. The key differences between your invention and the the one which they feel like it is prior art. Those key differences you have to tabulate it like 1-to-1 mapping. Don't write like in my invention this component is available, in their invention this component is not available. Don't compare physical entities. Always speak and make the comparison on the technical ground rather than the physical ground. So whatever you feel like, some best 8 to 10 points, key differences between these inventions like that. So comparisons between present invention and second invention, and comparisons with the present invention and the third invention. So once you have made those comparisons, next whatever the formal questions they have raised, for that you can give the detailed explanation. So sufficiency of disclosure, they ask a few questions, I gave a few answers, so like that. And as I mentioned earlier, for me they have asked me a model hardware implementation. So for that what I did is I gave an example over here with a valid proof. So I explained how my system is working. So depends on your system, you can put it. If you have any results, those results also you can keep it. So my design, I belongs to digital VLSI. System is prototyped on FPGA, my invented system. So I just give few example illustrations. Sorry. Yeah, this is a hardware I connected. This is a system, and system is my invented system is implemented on this one. And these are the waveforms, timing waveforms, which define the functionality of my invention. So since they have asked me a working model, I have done all these things. If they have not asked, then not an issue. Only you have to stick with the questions they have raised. So what are the modifications you are doing? You have to mention everything. What queries what they have asked, you have to respond. If they ask you to modify the specifications, you can modify it. Only I think as per the law, you are only allowed to modify the claims, and the remaining sections you should not modify. Only rewording here and there, avoiding some typographical errors and those things are allowed. But only thing is you have to intimate to the controller and you have to do modifications. So in this way you have to write a response and you have to file it. When you log into your account, it will ask file reply. There is a column file reply to the FER. If you click on that, it will ask you to upload the document. One document is the amended specification, other one is the FER response. Amended specification means yesterday, if you remember, I said like you have to upload marked copy and retyped copy. So in marked copy, you have to track all the changes, what are the amendments that you have done to your application. So I will just show you. So these are the amendments in my case. They have asked me to redraft the claims. So previous claims I have removed that I striked it off and I represented with marked text, and the new claims also I have drafted in marked text. This is the retyped, marked copy. In retyped pages, only the latest contents will be there. So you have to give retyped page, marked copy, these you have to upload, and reply to the FER you have to upload. Again, they will do one more examination. After that examination, what they will do is whatever the responses you have written, they will take into consideration if they feel like it is valid. Once if they feel like these objections, the objections for which you have written the responses is valid, then they will remove those objections. So for example, so they told this formal requirement is not satisfied. In the FER, they told it is not satisfied. But after that, I filed the response in the FER. If they feel like my response is valid, then they will remove these objections. So to grant patent, in order to get patent be granted, whatever the objections they are raising in the FER, all objections needs to be satisfied. Then only they will lift the objections. So your main aim is to get rid of all these objections. So in the FER, you can see there are so many objections. So for that, I have given a response. After the response has been given, they will examine it. And then what they will do is, if still any objections are still outstanding, then what they will do is they will call you for hearing. So hearing notice will be looks like this, and after thorough examination, what they will do is they will after examination, they will identify whether still any objections are outstanding. If there are outstanding, they will issue this hearing notice. From the date of issue, you will be given a date will be scheduled after 1 month. So it is scheduled on 2nd December. So on 3rd January, meeting has been scheduled. Mostly it will happen via video conferencing mode. They will specify you the date, time, and the link. When to join, and so on and so forth. So within 1 month notice they will give you, and in this objection they will tell like after going to the examination response to the examination report, we were satisfied at some point, but we were still not satisfied with few of the points, and some objections are still outstanding, that is pending. So within they will give you 1 month time. What you have to do is you have to prepare to defend all these objections and get rid of all these things. So once you receive this notice, you have to file a form to the patent office and tell like, I am ready to attend the hearing. On this date, on the scheduled date, you will be attending the meeting online. While attending that meeting, what you have to do is you have to be ready with the answers for those objections. So those answers you have to be ready, and those answers you have to present in front of the controller and discuss with him and try to convince him. Then the controller may ask you further questions about your invention, and then what he will do is if he raises any questions at that moment, you have to note it down, and then you have to give answers. So whatever you're communicating with them, everything needs to be documented. Once everything is documented, then he will give you, from the date of hearing, you will be, by law, you are eligible to get a time period of 15 days. Within this 15 days, what you have to do is you have to file the reply to the hearing notice. In this reply, again, it is same like as you have filed reply responses to the FER. So in this case, again, you will write the questions, what are the objections they have raised, and you have to communicate your responses. Anyhow, these things you have communicated orally at the time of hearing, but only thing is you have to document it once again. So for this, they will give you 15 days of time. Within 15 days, you have to do it. And they won't stick with only these questions which they have asked you in the mention in the hearing report. At the time of hearing, the controller may ask any questions related to the invention, depending on his choice and his preferences. So those things again you have to, because those questions anyhow not available in your hearing notice, what you have to do is you have to write it separately for your reference, and you have to, anyhow you will give explanation orally. Those explanations again you have to write in the written format. So everything needs to be documented. Again, you have to sign it If any patent agent is involved, he will sign, and then you have to file it. Again, for filing this one, there is no separate form mentioned in the patent law. So that's why what you will do is you will use form 30 to file it, but with relevant rules and section. In this case, it is section 14, rule 28 of 7. So you will identify those special category and you have to file it. Once you file this reply, then again it will go for examination. Then if the controller feels satisfied, he will grant the patent. So that grant will be communicated firstly by written letter that you will get it in the mail. So that one looks like this. This is the intimation of grant. So this is a written letter from the controller. After that, this letter you will get the patent certificate. That one looks like this. And this patent certificate, they will mention like every year. First of all, it is granted for protection for 20 years, and this 20 years time period will not start from the date of grant. It will start from the date of filing. You filed in 2021, but application is granted in 2022, but the protection is applicable from 2021 onwards, so for a period of 20 years. But a catch is every year you have to pay the renew fee. So here he will write your due date for the renewal of the patent fee patent is 19th day of every January for subsequent 20 years. So how much fee you need to pay in order to maintain your patent? If you're not paying the fee every year for renewal, then your patent will be ceased to be in force. Then so for that, what is the fees prescribed in patent office? Here you can see up to 2 years you need not pay any fee. Why? Because it will in the fast mode, in the fast track mode, it will take less than a year or less than 1.5 year to get a grant. So up to that you won't have any fee. You have to pay the fee from the third year onwards. So for third year rupees 800, for fourth year 800, like that up to 6 years it is 800. From the seventh year onwards it is 2400. It keeps on going for up to 10 years. The fees from 6th to from 7th year to 10th year it is 2400. From 11th year the cost is 4800 up to 15th year. For 16th year it is 8000. Up to 20th year it is 8000. So this is the overall cost for maintaining the patent. Once a patent is granted, patent certificate is issued, and subsequently in the next publication, intimation of grant will be published in the journal. So that is, we call it as notification, grant notification in the patent journal. So here you can see once it is granted, they will mention the details. What is the patent certificate number? What is the application number? What is the date of filing? What is the title of the invention? Who is the applicant? When the patent is, I think, granted, and from which office? When it is published, and when from which office has the patent has been granted. Similarly, when the first examination report has been generated, that also they will notify you in the journal. So again, it will have the office, from which office, what is the application number, when the patent FER report has been generated, who is the applicant, and a communication address. So these are the things. Finally, I will just open the online interface and I will show you if possible. Comprehensive e-filing and e-filing of patents. So this is the portal. If you have already filed a form 1, and then subsequent forms you can select whatever you want. So for example, if you want to file form 30, you select it. Then it will ask with fee or without fee. Maybe if you take without fee, then it will ask for which section and which rule you are filing it. Then here, suppose if you want to file retyped pages and marked copies, so you have to select this one, rule 14.1. I think whether it is visible or not. So retyped pages and marked copies, rule 14 of 1 and rule 14 of 2. So under that category, if you want to submit a response to the first examination report, you will have under section 21 rule 24b or 24c. 24c is for expedited examination response to expedited examination report. 24b is for the normal examination report. So here you have to enter the application number. Once if you enter the application number, it will try to fetch the details. So initially, if you want to file a patent, first you have to go for new application category. Then you have to go for proceed to e-filing. I think there is no biological patents involved. Any participants from biology side? If they're working with biological elements, then they have to get approval from the National Biodiversity Authority. If you are using any organisms or plant on animal based research, before filing the patent, you have to get this permission. If it is not applicable to you, you can go and click on directly to proceed for application. Here you have to select type of application, so ordinary application. Next, specifications, whether provisional or a complete. Next, enter the number of pages, number of claims, number of pages for the claims, number of pages for abstract, it should be 1, number of drawing sheets, total number of drawings. Sequence listing priority is not applicable because sequence listing is, I think it is for chemical patents. Priority based, because ours is ordinary application, we don't have any priorities. So you have to give the title of invention over here, address for communication, state. Depending upon the state of a patent office will be selected automatically. Mobile number, telephone number, email ID. Here it will ask you to write the abstract description claims, but these are very lengthy text. If it is possible, you can copy and paste it, but from LaTeX you cannot copy it. So you can write a generic statement like refer to the PDF attached. It's not mandatory to enter. Anyhow, there is no mandatory symbol. Only thing, if you enter here, it will be help them for the search engine to search the documents easily. If you can add the number of applicants, you can, by clicking on these applicants, if you have more than one applicant, you click it, you will get a separate row. Like that, you can add a n number of inventors, and then what you have to do is you have to save it. After you are saving it, here you have to go to the form history. In the form history, you have to click on drafted forms. So once if you have saved, your form will come in the drafted section. Here you have to select and you have to click on preview. If you click on preview, you will get a preview of the form. That form you have to save it on your desktop, download it. Then wherever the necessary signatures are to be there, you either place it using Adobe Acrobat or any other software tool, or else take the printout of that form, sign it manually and scan it in the PDF format. That PDF format you have to upload it over here. After successful uploadation, it will ask you to sign the documents using a digital signature certificate. So by that time your DSC should be connected to your computer and you have to click on the sign documents. Then it will show you the list of digital signatures available on record of your computer. Then assuming that your DSC is connected to your computer, select the relevant DSC and click on sign. Then patent URL, this application will try to invoke your DSC. Then you will get a dialog box and it will ask you to enter the DSC pin. Once you enter the pin, your DSC will be validated and it will fetch the signature details, and then it is assumed like your document has been digitally signed. Once it is signed, you will get a submit button. Once it is signed, your form now no more save remains in the drafted forms. It will go for the payments and submission section, as you can see here. Then you have to go to the make payment and submission section. There it will show you the forms which are available after signing. Then you have to select that form. Here itself it will show, depending on the details, how much fee you have to pay. If you click on submit, it will go to the payment page, payment gateway. There you make the payment. After successful payment, a CBR will be generated. You can download that CBR, that is for your reference, and you will also get an email acknowledgement of the CBR. It's like a payment receipt confirmation. Then you will be allocated an application number, and that application number should be used for filing subsequent forms. So you can file a form 2 similarly. Wherever you are selecting form, it is asking you section and rules. That's why I have clearly in my PPT I have mentioned what are the sections and rules for your better understanding. If you're filing an ordinary application, you can go through those details. This, yeah. Next, this on left hand side you have quick form filling. Similarly, you can select what appropriate form of your choice as per the guidelines of the patent. You generate those forms and upload it. If that form involves the fee, you pay it. Otherwise, in the submission itself, it will tell like this is a free form and payment is not required. There itself you will get direct submit button. You can submit it. So payment history, you can verify it after making all the payments. So CBRs and those things, the receipts will be available. You can download it at any time. So this is the brief overview of the online interface. One thing I want to mention is like this website requires you to access via multiple browsers at different points in time. Say for example, for uploading these forms, for filling these forms, say for example you want to generate a form 30 with fee or without fee. So for filling all these things, selecting the form, filling all these things and generating a form and then downloading it, after that signing and uploading, these all can be done through either Microsoft Edge or else Google Chrome. But while signing the forms after uploading your forms will go to form history. In form history it goes to drafted forms, right? Here you have to sign with your DSC. For this, for signing, I think I don't know why this convention is being followed by Indian Patent Office. Through Microsoft Edge and Chrome, we are not able to do it. Only you have to use the outdated old version of Internet Explorer. With that only we are able to get this sign, because we try to install all the latest DSC plugins available, but still we are not able to access the DSC through any of the browsers. Only in the Internet Explorer only we are able to use. After that, in digitally signing is over, you will get your form will enter into the submission and payment section. In this payment section, once your form is listed, it will ask you to pay the requisite fee, and for paying the fee it will not allow you to pay the fee when you are logged into either Internet Explorer or Microsoft Edge. You have to compulsory log into Chrome browser to make the payment. So I don't know why this issue is happening, but when you're not able to do all these things, don't get panic. So keep these points in mind. You have to switch between different browsers for doing this. This is as per my personal experience. Maybe whether they have rectified in nowadays or not, that also I don't know. Maybe after filing another application I will come to know. But over the past 1 year I have observed the same thing. So that's it from my side. So I think I have covered all the important aspects related to forms, fees, and filing procedures. From my end, the session is closed, and I want to acknowledge firstly Dr. M. Mahesh, Assistant Professor, Department of PCE, Madanapalli Institute of Technology and Science, for giving me this opportunity. I also extend my thanks to the organizing committee members of this workshop and the entire Department of PCE and the Madanapalli Institute of Technology and Science for inviting me to this workshop and giving me an opportunity to talk about a brief overview of patenting exclusively on Indian patent application filing. And lastly, the participants of this workshop. Yeah, thank you very much. If you have any queries, then I can address.
Any question from the audience? Please put your question in chat box. Any question? Participant, please. Same, sir.
Hello.
Yes, sir.
Yes, sir.
Sir, as you told, sir, every year we need to pay renewing fee at the patent office. So what happens if suppose we have filed a patent and it is granted, but after that we have not paying any renewal fee? Then what happens? It comes into public domain, or what happens?
Once there's no relevance in public domain, sir. Once the moment you file your patent and you ask you file a request for publication and examination, at that time itself your invention comes into the public domain. And the only thing is, after the grant, you will be your invention is bounded with the law, and you will be getting the protection so that no other people will be able to use it on commercial basis without taking your permission. But in order to make your patent to be in force, that is like active, every year you have to pay the renewal fee, and they will also give protection up to 20 years. After 20 years, it will become like an open source. But for 20 years, if patent office wants to give protection legally, you have to pay a fee for them. I think even if you have skipped the payment of fee, you will be given a grace period of, I think, 6 months, if I am not wrong. But within 6 months, again, you have to file a request for filing to give an exemption, and then you have to pay the fee. Once if you completely skip it to pay the fee, then that protection binding, what I told you, that will be seized, means they will stop it. Then later, after 2 years, you cannot come to patent office and tell like someone has used my invention, you please stop him from using that and give me a compensation. That you cannot claim. Why? Because your patent became inactive. Once it becomes inactive, again you cannot make it active. You can make it active only, I think, within 3 or 6 months, but beyond that they won't do it. That's it, sir.
Okay, sir. Okay. Thank you for giving the very detailed explanation of the procedure of filing your patent, and giving the details of each and every forms required. What is the meaning of each and every form? So we are thankful for you from all the participants. So I request Mahesh sir, please. Hello?
Sir, thank you, sir. Sir, now I would like to request our HOD sir to give a few words about the session.
Yes, sir. Thank you, sir. Thank you, Mahesh, sir. So, good evening, one and all present in this meeting. First of all, I thank today's chief guest, Mr. Satish Sai, sir. So, our Department of EC, Electronics and Communication Engineering, Adapalli Institute of Technology and Science, organized a 5-day workshop on the art of patenting and drafting from 25th to 29th. The event was grand success. We have got more than 80 registration, and every day we had minimum 70 attendees. Initially, we did not know about the process of patenting and patent drafting and filing. After listening to this workshop, we learned many things. Not only me, all the participants. Hereafter, instead of publishing paper in journal and conference, we also will go patenting. We will motivate our faculty and we will motivate our students for patenting. That much knowledge we got with the help of the eminent speakers from Patent Office. I thank the resource persons accepting our invitations and presented these wonderful sessions. I thank event coordinator Dr. Makesh, Dr. Nanda, and Dr. Sangraprasad Bhag, and all our faculty members. And thank you, one and all present in this meeting. Thank you, sir. Okay, sir.
Sir. Sir, is vice principal sir available, sir?
No, sir. That's all, sir.
Okay, sir. Then we'll go with the valedictory.
Yes.
Yes, sir. Myself, Dr. Mahesh, a very good evening to all. Welcome to the valedictory session on the art of patenting and drafting. So over the last 5 days, we had a deep insights into the intellectual property rights and what actually is the patents, given by many eminent speakers, not only academicians, but also speakers from Indian Patent Office and patent attorneys of different companies. The total session we have focused in what actually is the patents and how to file a patent from scratch to the grant of the patent. And also we learned how to draft a patent if we are doing individual. So I hope this the workshop on the art of patenting and drafting is a grand success, and hope the participants have had a very informative and productive session. So in this regard, I thank our secretary and correspondent, Dr. N. Vijay Bhaskar Chaudhary Garu, as well as our principal for cooperating to conduct a smooth conduction of this program. Our principal, Dr. C. Yuvraj, sir, as well as our HOD, Dr. S. Rasekaran, and all the organizing committee members for smooth conduction of this program. With this, I announce that the program will be concluded here. And for the certifications, we will communicate you shortly. And one final thing before closing this session, now all the participants will receive a link to upload the feedback regarding this program. So I request all the participants to fill it. Thank you very much.
meeting
Thanks.